Okay, we've got one more that needs to come in here. All right, good afternoon, and thank you all for joining us for today's A Month of Service presentation of the overview of bankruptcy. My name is Nia Murray. I am the programs coordinator with Neighborhood Recovery Community Development Corporation, and we are one of the partners in the A Month of Service collaboration. Also included is the City of Houston's Department of Neighborhoods, Lone Star Legal Aid, Harris County Tax Assessor Collector's Office, the Earl Carl Institute, Harris Central Appraisal District, Houston Bar Association, as well as Houston Volunteer Lawyers. And together we make up A Month of Service. And basically what A Month of Service is, it's a collaboration of all 8 different organizations that you see here. We come together on a monthly basis and we offer a variety of different workshops relative to community empowerment, asset building, asset protection, and the maintenance of generational wealth. So we know that there's a lot of underserved communities that are out there that don't have access to a lot of information or to particular resources. So we wanted to come together and create a larger impact, since we pretty much all service the same communities, and wanted to get as much information out there to the public as we possibly can and let them know what their rights are, what services are available, and the available options that they actually may have that they may not know about. So again, we want to welcome you all for joining us for this afternoon. For those that are attorneys that are joining us, if you're joining us for the first time, please note that if you see a course number outside of any of our workshops, you have the opportunity to take advantage of free CLE credit on behalf of the Houston Bar Association, who sponsors those credits. In addition to that, I just wanted to let you know that the information that is presented here today is for educational purposes only. It is not to be considered legal advice. However, we do encourage you, if you do find yourselves in need of any civil legal assistance, that you reach out to our legal service partners that are listed here, or if you need specific information in regards to bankruptcy, that you can reach out to the presenter that's Ms. Megan, who's going to be giving you the information here today. In addition to that, please note that we are recording this session for everyone to go back to view again, and we will be providing a link as well as we are recording on our social media platform at Amos Houston TX, so that you have the opportunity to go back and watch it there as well, or share it with someone else that also may find the information to be beneficial. But do keep in mind, this is a public forum, so we ask that we encourage you to be as interactive as you'd like to be. If you have any questions, please feel free to type them into the chat. If you join on Facebook, type them into the comment section, and we'll make sure that your question is read aloud at the end of the presentation, or you have the opportunity to unmute yourself and ask your question of Megan directly following the presentation. Again, we want to try to protect your privacy as much as we possibly can, so we ask that you try to keep your questions to be general and not real specific in detail, again, because it is a public forum. In addition to that, then you don't want to cross the line of giving legal advice versus just providing information. So try to keep them as general as you possibly can. So with that being said, Ms. Megan, we're going to have you go ahead and introduce yourself, and we're going to move right on into our presentation. Looking forward to hearing a lot of information that you got to share with all of us today. So thank you very much for being here this afternoon. We're going to let you go ahead with the presentation.
Perfect. Thank you so much. And thank you so much for having me. So my name is Megan Deitch, and I'm the owner and attorney with Deitch Law. I'm also adjunct faculty at University of Houston Law Center, and I'm the director of our Alternative Dispute Resolution Program. I love finding solutions to problems for people. And so part of that with my firm, we assist individuals who've been sued by creditors or who are looking to file bankruptcy. So we do provide, analysis and discuss options with people regularly. I will let you all know that today I plan on speaking primarily about Chapter 7 bankruptcy, which I'll talk about the different types of bankruptcy in a few moments. But most of the information will be geared towards that, because I figured we are speaking to individuals in the community. There's a good chance we're looking at Chapter 7 bankruptcy. But again, like was mentioned earlier, if you are needing legal advice, you have various legal services here and lots of attorneys in town who handle Chapter 7, Chapter 13, Chapter 11 bankruptcy. I do have a presentation for you all, so I'm going to go ahead and share my screen. And so I just wanted to check, make certain that you all can view my screen. If so, thumbs up. Perfect. Great. Okay, so we're going to go over a bankruptcy overview. For those of you out there, if you'd like to stop me and ask questions, please feel free to do so. For those of you on Facebook Live, as was mentioned earlier, feel free to go ahead and type your questions into the chat box, and then they'll relay those at the end. So this is our bankruptcy overview. So really, what is bankruptcy and what should I know about it? So here are a few things that we'll be talking about today. Like I mentioned, there are various types of bankruptcy. We'll go into those each briefly, and then we'll go into more, deep dive into Chapter 7 bankruptcy, including what is a means test, what documents would I need, how would I know if I qualify, and even if Chapter 7 bankruptcy would be a good option for me or for my loved ones, and also alternatives to bankruptcy. So at a very high level, bankruptcy, it is a legal process that allows individuals, businesses, or entities that are unable to meet their financial obligations to either reorganize their debts or obtain a fresh start by having some or all of their debts discharged. And so there are, like I mentioned, various types of bankruptcy. So there's Chapter 7 bankruptcy, which most of you have probably heard about at some point in time or another. This is going to mean liquidation. So this involves selling non-exempt assets, if you happen to have any, to pay off creditors and discharging remaining eligible debts. So what happens in a Chapter 7 bankruptcy is if you do qualify for this type of bankruptcy, which is primarily consumer bankruptcy for consumer debts, things such as credit card debt, personal loans, maybe even medical debt, things of the like. And if you do qualify and your income is not too high, as well as some other qualifications as well. And if this is a good option for you, there's an assessment to see what assets that you have that would be exempt and what would be non-exempt. So for instance, if you were to own multiple properties and had rental properties, your first property or your homestead would be exempted, but your remaining properties would likely not be exempted. So doing an analysis there, if you do have any non-exempt assets, then those get sold to pay your creditors. But if you have all exempt assets, these debts should just go away at the end of the bankruptcy. It is a 90-day process from the date of filing, and it does last for 8 years. But again, we'll go into it in more detail in a little bit. There's also Chapter 13 bankruptcy. This is reorganization. So this involves creating a repayment plan to pay off a portion or all of the debts over a set period of time. Typically, we see this around 3 to 5 years. So what you may see is maybe a reduction of those debts with creditors. Maybe some of those debts go away, but you go on to this payment plan to pay back the creditors. They do an analysis of what your income is on a monthly basis and try to structure the plan based on that and based on your creditors and the percentage of income and debt. Chapter 11 bankruptcy would be reorganization for businesses. So this is primarily used by businesses to restructure their debts and continue their operations. So typically when you hear about large companies that have had to file for bankruptcy before, this is usually the type of bankruptcy that they're filing under. There's also Chapter 12 bankruptcy. This is reorganization for family farmers and fishermen. So it's designed for family farmers and fishermen to restructure their debts. So really, who is eligible? What is exempt? What is not? What happens to my current debts and lawsuits? And what happens to judgments? So these are a lot of questions, which I'm happy to take one at a time, and we'll kind of discuss them as we go along as well. But again, my goal for today is really to focus on Chapter 7 bankruptcy. So to determine whether or not you're eligible, we do have to do an analysis to see if you qualify under the means test, meaning that you're earning under a certain amount of income annually. And so the Department of Justice actually determines the means test amounts. And then we look at your income, maybe your pay stubs, profit and loss statements if you own your own business, other ways to show and prove your income to determine if you are going to be eligible. There are other considerations as well. So for instance, if somebody comes to me and they let me know that they are at risk for foreclosure of their home, or if they're behind on payments with their vehicle and they would like to keep their vehicle, Unless they can get caught up on those payments before filing bankruptcy, we'd probably recommend them, having a discussion about a Chapter 13 bankruptcy so that you can reorganize those debts, go into payment plans with those creditors in order to try to keep those assets. As far as what is exempt and what is not, we won't go into this in too much detail, but I am happy to answer questions. Again, under Chapter 7, we're looking at, do you have any non-exempt assets that could be sold to pay your creditors with? So most of the time, the things that you're going to get to keep in a Chapter 7 will be things like your home, your homestead. You're typically able to keep a number of vehicles equal to the number of licensed drivers in your household. Also things such as your household goods and furnishings, appliances, furniture. You're able to keep up to a certain amount of jewelry as well. It just depends on like a monetary amount. Things such as like a 401k, that you're going to be able to keep as well. In the state of Texas, it depends on whether or not we have to use Texas exemptions or federal exemptions. A lot of that depends on whether or not you have a homestead as well as some other factors. But if you do have a homestead, we're likely looking at using Texas exemptions. Under Texas exemptions in Chapter 7 bankruptcy, we do not have the option for something called wild card. So let's say you have a lot of money in your bank accounts or you keep a lot of cash on hand. These are things that likely would not be exempt, and a bankruptcy court or the trustee may take those funds in order to pay your creditors. However, if you do not have a homestead, we could use federal exemptions. Under federal exemptions, they do have something called wild card. So we would actually be able to use the wild card exemption for up to a certain amount for those items, such as, again, money in your bank account, cash on hand, those sorts of things. So moving on to current debts and lawsuits. So for the most part, in a Chapter 7 bankruptcy, most of your debts will be included, most of your consumer debts. So again, that's going to be things such as credit cards, personal loans, medical debt. Certain things that do not get included. The first one being, there's a caveat, is student loans. We know that there are some big changes in the works right now with student loans. Right now, we are not exempting any student loans. We're currently going through the training to learn about these processes and what the DOJ is actually allowing, as this is kind of new and it's not applicable yet in necessarily all states. So there is a bit of a caveat or an asterisk related to student loans. Some other things that are not included in bankruptcy, though, would include things such as child support payments, payments to the IRS, or for payments for property taxes. And let me see, and things really of the like, which we'll go into a little bit more later on too. As far as lawsuits go, if you do have any lawsuits against you, primarily debt lawsuits, that's what we see a lot of the time. So it may be a creditor that's filed a lawsuit against you for a credit card debt that you've now defaulted on. So what would happen with those is they would likely be included in the bankruptcy. We actually can pull it directly from your credit report. And those would be included, and those could go away or be discharged with the bankruptcy. Same thing with lawsuits. If you have a pending lawsuit, or even if you have a judgment. So if it's already gone away, all the way to a judge, and a judge has granted a judgment in favor of the plaintiff, then we should still be able to include that as well. Great. Okay, so the filing process, we really always start with, this is assuming we already have all of the information we need and we can draft the bankruptcy petition. So the document or instrument that we use to file the bankruptcy is called a petition. So there's the petition, which is going to have a lot of your background information, contact information, those sorts of things. And it's also going to include schedules. So that will include things such as your assets, your liabilities, your income, your expenses, and statement of financial affairs. So we start by filing that petition with the bankruptcy court. In a Chapter 7 bankruptcy, from the day that we file the bankruptcy to the day that the bankruptcy case is discharged and closed, if all goes well, it is a 90-day period. Within the first 30 days, though, we should have something called a 341 meeting of the creditors, which I'll talk about more in a little while. So again, part of the petition, we're including various information such as financial information, income, assets, debts, and expenses. Then, like I mentioned, 30 days later, there's going to be this meeting of the creditors where the trustee and creditors and potentially the US trustee can ask questions. In a Chapter 7 bankruptcy, we don't see a lot of creditors attend often, unless there's been some sort of a hiccup, usually. So it's typically going to be the debtor that's filing bankruptcy, the debtor's attorney, if they do have an attorney, and the bankruptcy trustee. The trustee will have already reviewed all of the documentation prior to this meeting. They've reviewed the bankruptcy petition and the schedules, and they're going to ask a series of questions, which it may vary based on which district you're in. In Texas, we do have 4 districts. We have the Northern, Southern, Eastern, and Western district. And depending upon where you live and where you've resided primarily over the last 180 days, will determine which district you'll be filing in. So an automatic stay. So once the bankruptcy petition is filed, an automatic stay goes into effect, which kind of halts most collection actions by creditors. This includes lawsuits, garnishments, foreclosures, and repossessions. So creditors are notified. There's a verification of creditor matrix, which is created basically from your credit report and a list of creditors that you provide your attorney or the bankruptcy court with. Everything pretty much gets stayed. They get notification, they know, okay, we need to halt any further procedures. Exemptions. So bankruptcy law does allow debtors to keep certain types and amounts of property, which are known as exemptions, and these do vary state by state. So again, I'm a Texas attorney. I am licensed in the state of Texas. Everything that I'm discussing today is primarily relating to the state of Texas. And so I have a lot of clients or potential clients call and they say, I'm just so worried I'll lose my home or I'll lose my furniture or, some valuables that have sentimental value, for the family, pictures and things of the like. And so we try to guide them through this, to say, look, here's what they can take, here's what they're not going to take. And we don't want you to have to worry about that, but we do need to have a very honest and realistic discussion about what those assets are. So for instance, if you, let's say, have some antiques or collectibles that you are trying to hold on to and you haven't informed your attorney or haven't informed the bankruptcy court, that would be problematic, especially this is federal bankruptcy court. And so you do have to, be sworn in and swear to tell the truth, the whole truth, and nothing but the truth. So it's always just best to provide all of the information about your assets upfront to the best of your abilities. So these exemptions protect essential assets from being sold to pay off debts. I know I mentioned earlier things such as your homestead, your vehicle. So again, let's say you have 3 people in your household and 3 of them are all licensed drivers. Your household could keep and maintain 3 vehicles. Again, as long as you're current on all of your payments for those vehicles. Household goods and furnishings, appliances, clothing, your pets, of course, things of this nature. You can even include a certain amount of like sports equipment or workout equipment, firearms up to a certain amount. There are a number of things that you'd be able to keep. 401k, that is usually also always exempt. Life insurance policies usually always exempt as well. So there's a lot that you do get to hold on to. Again, they're really just looking for those non-exempt assets that they can use to pay your creditors. Now, prior to filing the bankruptcy, there are going to be a series of things that need to happen beforehand, starting with providing information to your bankruptcy attorney or providing it to be able to draft the bankruptcy petition and schedules. The next step, though, is to take a credit counseling and education course. So there are actually 2 education courses that you would need to take as part of the bankruptcy. The first is called credit counseling. And so with that, it's usually around a 90-minute course that you can take online or over the phone, typically. When people sign up with us and we're handling bankruptcy for them, we actually sign up for the course for them. It sends them the login information or the phone number so that they can call in. And really they're looking at getting some information. So you'll have to go through and essentially set up a budget. So they are really trying to help you and advise so that they can sort of guide you and educate debtors on how to avoid filing for bankruptcy again in the future. So you do have to include information such as your income and your monthly expenses. Those are going to be the main things. I have heard from quite a few clients that they thought that the information was really informative and very helpful. I think a lot of people are really missing that financial education that we all really need and really hope for, and we just don't really get growing up. And so I do like to look at bankruptcy as being light at the end of a tunnel. It is not a first resort. I will advise people first on what are some other options. Let's look at what your total debt is and figure out if there's a way to make this more manageable. But if all else fails, we can definitely look at bankruptcy as an option. And I think it just provides a lot of ability to take away some stress and create some ease and peace of mind for people, especially if you're receiving lots of calls from creditors, or if you, like most people, are just the kind of person that you feel badly that you cannot pay back these debts, but you've ended up in a situation where it's just not feasible. Especially with interest rates nowadays that we see on various credit cards and loans. A lot of the time it feels like we're kind of being set up for failure. Most of the time with most of my clients, it is personal and family matters that occur that cause people to have to file bankruptcy. So things such as loss of a family member, loss of a job, medical expenses. I've seen it before with people with, of course, hundreds of thousands of dollars or almost $500,000 in medical bills that they just would not be able to recover from. Divorce, that's another big one that we see. And having to take care of loved ones, right? Having a loved one who becomes sick. So these are things that make it really difficult for people to be able to make that hard decision of, do I pay to keep a roof over my head and food on the table and the lights on? Or do I pay, for this credit card bill or this loan that I took out, a year or two ago? Okay, and so then as part of the credit counseling and education, just so you know, after you file the bankruptcy, there is actually a second course that you will take as well that sort of complements the first one. It's called a financial management course. It's similar. It should last up to around 90 minutes and usually can be done online or over the phone. Once that is completed, the certificate of completion is filed with the bankruptcy court. Prior to the bankruptcy being filed, the credit counseling certificate is filed with the bankruptcy court. Okay, and then another term to know is bankruptcy discharge. So bankruptcy discharge is the court's order that eliminates the debtor's legal obligation to pay certain debts. Again, not all debts are dischargeable though. So certain things such as child support, spousal support, taxes, and again, the caveat for student loans are likely not going to be discharged with the bankruptcy. And I say likely because of student loans, the rest are not going to be discharged with bankruptcy. Another big question that we get a lot of the time is credit impact. So a lot of people are really worried about the impact that filing bankruptcy will have on their credit. And so there are kind of a couple of different ways to look at this. The bankruptcy itself, from the day that you file the bankruptcy, lasts for 8 years, meaning you cannot file bankruptcy again for another 8 years. The bankruptcy, however, will last on your credit report for 10 years. And it is true that bankruptcy can negatively affect your score and remain on the credit report, again, up to 10 years in Texas, which may make it more difficult to obtain credit and loans in the future. The flip side of that is you can't file bankruptcy again for another 8 years. So what happens a lot of the time is my clients reach out to me and they say, hey, Megan, the bankruptcy is discharged and closed, and now I'm getting a lot of credit and loan applications. I thought that this wouldn't happen because I filed for bankruptcy. Well, again, you can't file bankruptcy again for another 8 years. So I just urge people to use caution and to be careful, especially when you do start receiving those applications. The other flip side to this too is while bankruptcy is going to be taken into consideration by creditors, you would have to let creditors know, let's say you were trying to get a loan for a vehicle. It can affect things such as renting, because usually they will ask if you have filed for bankruptcy before. The flip side to this is that typically within about 12 months, you would actually see a positive increase in your credit score. So the system that we run where we pull your credit report, we can usually see your 12-month post bankruptcy credit score, which usually has an increase anywhere from maybe 40 to 100 points. And that's because those debts that previously existed are no longer going to show on your credit report. They no longer exist. So these are not outstanding debts any longer. So another term to be aware of is the bankruptcy trustee. I like to think of them as the little t trustee and the big T trustee, which is the US trustee. When it comes to Chapter 7 bankruptcy cases, we are always dealing with the little t trustee, who's been assigned by the bankruptcy court to review the bankruptcy petition, schedules, statement of financial affairs, and to make sure that everything looks good to go and that there aren't any, lingering questions or issues. The US trustee usually gets involved if there is an issue that they need to address. So sometimes in the creditor meetings, they may come in and have some overarching questions that they need to ask. Doesn't happen often, but it can. So the trustee is appointed to oversee the case, review all of the documents, including financial documents. That would include things such as pay stubs, bank statements, and manage the sale of any non-exempt assets in Chapter 7 if you had any non-exempt assets. In Chapter 13, they actually administer payments. So there's, I think, a lot of work involved with that. Okay, and so repayment plans in a Chapter 13. So in Chapter 13, debtors propose a repayment plan outlining how they'll pay off their debts over a specified period, which again is typically 3 to 5 years. When people do contact my office and they're trying to get a consultation and analysis of Chapter 7 bankruptcy, if they do not qualify, some of the biggest reasons for lack of qualification would be that their income is too high. So we will look at their last 6 months of income, gross, not net. So gross, and compare that to the means test numbers that the Department of Justice provides us, which I'll show you a chart in a little bit. To determine if they would qualify. I'll look at pay stubs, we'll take everything into consideration. Another reason, like I mentioned earlier, that you may not qualify for Chapter 7, or it may not be a good option for you, is if you were behind on your mortgage payments, or let's say you own an RV and you're behind on your payments on your RV, and you are wanting to keep the asset. Same thing with a vehicle. If you're behind on your loan payments and you'd like to keep the asset, but you cannot get caught up, Chapter 13 may be a good option for you because you could go on those repayment plans and potentially get to keep that property. So at this point in time, I know I've been talking for a while. If anybody wants, feel free to drop questions in the chat and I'll respond for a few minutes. If not, we'll just keep going and we can open up to questions at the very end.
We can go ahead and we'll answer at the end.
Perfect. Sounds great to me.
All right.
Okay, wonderful. So I know I mentioned to you all a moment ago that I would show you this chart. This is just a screenshot of the chart you can see here for Texas. This comes from the Department of Justice website. So the means test, it's a questionnaire that calculates whether or not you have the means to pay back what you owe to your creditors. If your income is too high, then you may not be able to qualify for Chapter 7 bankruptcy, and instead you would have to likely consider Chapter 13. So right here, when you see Texas, and we've got these different amounts here, the $60,040, that's for a household of one. So if your gross income, and this is total income, so I'll go into that in more detail, but if your total household income gross is more than that $60,040 annually, then you would not qualify for Chapter 7. If you look at a household size of 2, so $77,611, if your income is more than that, you would not qualify. Now, one question I get often is, well, what if I'm married, I have a spouse, but I only intend to file bankruptcy as single. My spouse is not filing bankruptcy with me. Why do they need to consider my spouse's income as well? And so what happens here is, again, all household income is considered. So if you receive money from family members or from friends, or if you have retirement benefits that you're receiving, These are things that may all be considered as part of the income. Same thing if you have a spouse, especially Texas, as you know, is a community property state. I think that the state probably views it as your spouse would be able to assist you with some of these debts so that you could avoid filing for bankruptcy. Again, bankruptcy should be kind of a last resort, not the first go-to or first option. And you can see here that it increases. So for a household of 3, it's 87,228. Household of 4, 101,753. So again, if you are earning below these amounts for a household that size, then you could qualify for Chapter 7. There are still other questions to answer, things to know, but this is kind of the baseline test. And you can see here it says add 9,900 for each additional, for each individual in excess of 4 in the household. Okay, so this is really just a list of questions to consider. So some things that you may want to consider, which I know that we kind of talked about a little while ago, is how will bankruptcy affect my credit score or my ability to obtain credit? This is something you want to have some answers to. What documents are required, which we'll go into in more detail. What are the benefits? What are the disadvantages? How often can someone file for Chapter 7 bankruptcy? Again, can I file single? Can I file jointly? Again, if you do have a spouse, that does not mean that you're required to file jointly. You do not have to. But just keep in mind that if you do file single and if your debts fall under both of your names, then your spouse would likely then be individually liable or responsible if they were not filing for the bankruptcy as well. How is income calculated for the means test? Just something I'd like to point out, certain non-taxable income such as Social Security or Social Security disability income are not included as part of the mean test. But how is income calculated for Schedules I and J? This is for income and expenses. The weird caveat here is that all income, including Social Security and disability, are included for your income and expenses, which sometimes becomes a little problematic if your monthly expenses are pretty low, because we're looking at your monthly net disposable income as well. And so it's possible that you could shift to a Chapter 13, even if you qualify under the means test. What does bankruptcy not do? Which those were some of the exceptions that I talked about earlier, such as child support, potentially student loan payments, spousal support, and taxes. And then what are the steps involved in filing Chapter 7? So what are the steps involved? So the first step would really be to pass the means test. So you would either determine on your own if you're representing yourself in your own bankruptcy, if you do qualify under the means test, or your Chapter 7 bankruptcy attorney would be assisting you with that. It is likely that they will need your last 6 months of pay stubs in order to make that determination. So I just wouldn't want you to be surprised. If you do have multiple jobs, they would likely need to see pay stubs for each job. And then provide requested information. So there's usually going to be an intake form. With my firm, for instance, we have, I think it's a 17-page intake form. It asks a lot of questions, mostly about, who are you, where have you lived, who's in your household, what is your employment status, who do you work for, and again, income, expenses, assets, and your liabilities. Bankruptcy court is also going to require the last 2 years of tax returns that you have filed. If you do have a pending tax return, they will likely ask you if you expect an anticipated refund. If you are, it is possible that the bankruptcy trustee may end up keeping your bankruptcy open until you receive those taxes, and then, or that refund rather, and then take those funds to pay your creditors. It all depends. Pay stubs, again, the bankruptcy court will be looking at the last 6 months of your pay stubs. If you do not have a form of income, if you do not have any pay stubs, then there is a document that gets filed with the court that just indicates that you do not have any payment advices or pay stubs. Bank statements, same thing. They're going to be looking at the last 6 months of your bank statements. One thing that's really important to note is in the last 12 months before filing, you should not be paying back money or making payments to insiders or transferring property. An insider usually constitutes somebody that's, let's say, a friend or a family member that you are basically making priority over and giving them money back versus paying your other creditors who may have a higher priority. So you should not be doing that. You should, be needing all of the money that you do have to pay for your own personal expenses. Because if you are paying for expenses for other people outside of your household, or let's say for non-dependents, then it gets, constituted or seen by the bankruptcy court that you should be able to take that money and pay your creditors instead and try to avoid bankruptcy, or at least go into a Chapter 13. You'll also need to provide proof of identification. Typically, this looks like your driver's license and social security card, typically front and back. And then again, there's the credit counseling course. So that's that 90-minute course that you would take prior to filing the bankruptcy. After the bankruptcy petition and schedules are filed, there then is an assignment of the trustee. So you would receive notification of who your trustee is. They typically have an electronic portal for you to upload your documentation. So again, the documents that we mentioned earlier, you would provide that documentation as well as possibly a few other things. Then in some, there's also a 341 meeting questionnaire. So there's a questionnaire as designated by the bankruptcy court that asks a lot of different questions. A lot of the questions you'll be answering to your attorney, to the bankruptcy court on the questionnaire and the petition and schedules are very similar and very redundant. So just be patient with the process. There is a lot of information that it calls for, and there are redundancies, which I believe are also helpful too in making sure that we're clear on the information and that people are being as truthful and trying to include everything as much as possible. The next big step is going to be that meeting of creditors, which is the 341 meeting. This meeting, at least as of right now, as far as every district that I'm filing bankruptcy cases in, which is all of the districts in the state of Texas, the meeting of the creditors is taking place telephonically. So we are provided with a teleconference number and a passcode. You would call in on the day and time of your meeting and you would go on mute. And then the trustee and or your attorney would ask you various questions. They do start by verifying your identity. They like to ask if you filed for bankruptcy before, why you're having to file bankruptcy, if you've listed all of your property or assets in the petition and schedules, if you were currently employed, these sorts of questions. A few other things that they do ask is really if you're expecting a windfall anytime soon. So really, if you were to get any large sum of money within the 6 months after the bankruptcy, then there's a windfall provision. You'd be required to notify your attorney and the bankruptcy court of that. So things that we're kind of looking at as far as a windfall is, do you have any claims against third parties where you may be expecting a sum of money? So for instance, do you have an outstanding insurance claim? Do you have a personal injury claim? Or maybe you have an attorney and they're helping you to seek money damages due to, let's say, a car accident. Do you have any sort of labor and employment dispute? Or even, are you expecting an inheritance in the near future? Because these are things that the bankruptcy court would need to be notified of. And again, after filing the bankruptcy petition, you would take that second financial course. It's the financial management course. 60 days after the 341 meeting of the creditors should be the date of discharge. You likely won't receive much of any documentation or notification before then, other than if you are reaffirming a debt. So if you do own a home and you're paying a mortgage and you would like to keep the home and continue making those payments each month, or if you have a vehicle or multiple vehicles and you're still making loan payments on those, we would request something called a reaffirmation agreement, which basically means that that debt will remain on your credit report. You do still owe that debt and it's not included in the bankruptcy. You are reaffirming that you would like to keep that property in exchange for continuing to make your payments each month. If you end up missing your payments and you default with that creditor was not included in the bankruptcy if you've reaffirmed the debt. So if you prefer to, let's say, surrender a vehicle in bankruptcy, you do have that option, and then you would no longer have that financial legal obligation if you choose to surrender it instead. Okay, so what is not included in Chapter 7? We've talked about this quite a bit already. One thing that I didn't mention, I know I mentioned debt lawsuits against you. Those can be included in the bankruptcy. But there is a caveat for some different types of lawsuits, which could include, let's say, fraud claims. So if you are sued for fraud, or if you have criminal claims, those likely are not going away in the bankruptcy. You would need to notify the bankruptcy court. And there could even be a hearing or a trial in the bankruptcy case related to, let's say, a fraud claim or criminal claims. So what are some common issues that we see in bankruptcy? So one of the first ones that I mentioned is payments to insiders. So an example would be is, let's say I'm filing for bankruptcy, and within the last 6 months, I have a sibling who loaned me $10,000. And I decided in the last 3 months to pay them back that $10,000. That would be considered a payment to an insider. So I did not use that money to go towards my other creditors first. I used it to pay back a family member of mine. Payments to insiders are really frowned upon by the bankruptcy court, by the trustee, and they may require you to either pay back that money to the trustee so that they can then pay your creditors. So you may go on a payment plan with the trustee, or in order to get your creditors paid. Or they may even go after your family member to try to recover that $10,000 that I paid them, or paid them back. And so they may even go after them. So it's really important that you're not placing priority on these insiders. Compensation owed by third parties. This is going to be a question that the bankruptcy trustee will ask is, does anybody owe you any money? So if there is any individual that owes you money that you've been unable to recover, then the bankruptcy trustee has the ability and may go after that third party to try to get that money from them. Unfortunately, when I've seen this happen before, usually it's that somebody got defrauded, and the person who has the money is likely overseas. The federal government is involved and nobody can locate them. So it ends up being very problematic. And unfortunately, it happens way more often than it should, which leads to people needing to file bankruptcy. Pending insurance claims. So let's say you have an insurance claim pending on your roof for some hail damage, or on your vehicle for hail damage, or for an auto accident. They're basically going to wait to see what those insurance proceeds are, and see if there's any money left over that they could use in order to pay your creditors. Okay, we have a question about IRAs, which I can address a little bit more later on, but I would need to check again. I don't know why I always have to look at IRAs to see if they're exempt, but my understanding is yes, I think a typical IRA is going to be exempt. So sort of like a 401k, but I will look into that again just to confirm and make certain. Again, I mentioned a windfall. So in the 6 months after you file the bankruptcy, if let's say you win the lottery and you become a millionaire, you do actually have to say, like, part of filing the bankruptcy is that you agree that you will inform your attorney, and your attorney will inform the bankruptcy court, or you'll inform the bankruptcy court directly if you represent yourself, that you have received a windfall. So you're now a millionaire because you won the lottery. And then they would, have to enter into a payment plan with your creditors to get them paid back. So of course, just making sure to, properly communicate those things with your attorney and with the court. Some other issues that I've seen before would be multiple properties. So a lot of the time, I've spoken with people who they have a homestead, but then they also own a rental property or some sort of an investment property, or they have a property that they own with their siblings. This can be problematic because your homestead is exempted, but any properties outside of that are not going to be exempted, unfortunately. I also mentioned earlier, if you're behind on your mortgage or car payments, you likely are going to want to elect a Chapter 13 in order to keep those. Typically what happens is I get a call 1 or 2 days before a property is going into foreclosure. Someone says, I need to file bankruptcy. You would probably need to find a Chapter 13 bankruptcy who also will do an expedited bankruptcy, because obviously time is of the essence there, because you need that taken care of as soon as possible. Again, if you don't, let's say you're behind on your car payments and you file Chapter 7, if you are behind on those payments, you will lose the vehicle. So just something to keep in mind. And I touched on it briefly earlier, but issues with your schedules I and J, this is income and expenses. So let's say I qualify under the means test because my income, my total household income, qualifies me under the means test. But let's say I get a lot of money each month in disability income or Social Security, which we don't include, we don't factor into the means test. What can happen is when I take my monthly expenses, or I'm sorry, my monthly income, total income, that would include even Social Security, minus my monthly expenses. If I have a large monthly disposable income, net monthly disposable income left over. So let's say I've got, 5,000 in income, which includes my Social Security or disability, whatever it may be, minus, let's say I only have 2,000 in expenses, which I see a lot of the time when people own their homes outright, so they don't have a mortgage payment, their expenses are a lot lower than individuals who are still paying a mortgage or who are, let's say, paying rent, which usually ends up being even more expensive for the most part. So let's say I've got that, 5,000 minus 2,000 and my monthly net disposable income is 3,000 a month. That would be problematic. And the reason for that is because that means that I do have money left over each month that I could use to pay creditors. So it is likely that the bankruptcy trustee at that point would convert you over, or convert me in that scenario over to a Chapter 13 bankruptcy. So if I get the feeling that the expenses will be rather low, even if somebody qualifies for the means test, we actually do an assessment of, we have a form say, hey, fill out your monthly income, your monthly expenses, so we can take a look at it and make a determination from there as to, what's really in your best interest. Because I would hate for somebody to think that they're going to have this discharge and then all of a sudden it's converting to a Chapter 13 and they're saying, well, I'm reorganizing my debts. I'm having to go on payment plans with my creditors. Could I have done that myself? And the answer, I believe, is sometimes that's an option. Even with clients who have debt lawsuits, if somebody comes to me with one debt lawsuit, unless it's a really big, debt amount, my recommendation to them is usually, hey, why don't we take this one at a time? And we can always convert you over to bankruptcy later if need be. But if I can get this resolved for you, I can get a good payment plan, or I can win for you. That might be a better option. So I really think it's taking a holistic view of the individual or the couple that is looking to file bankruptcy jointly, and helping make a decision as to what really is in your best interest and what makes the most sense. For a lot of people, what it really comes down to is kind of the stress and feeling overwhelmed. So when people come to me and they say that, I don't want to have this hanging over my head. I don't want to be receiving calls from creditors. I'd like this to just be done and over with. I completely understand that as well. It's very viable. So I know I just mentioned that. What are some alternatives to bankruptcy? Again, we kind of do this assessment of your assets and your liabilities first. I do, check and see if there is a judgment, or if there is going to be a judgment in the future, what sort of assets do you have, if any, that a creditor could use to try and seize, repossess, garnish, or levy? And are there potential solutions to avoid bankruptcy? I mean, I think the answer is, of course, yes. And I think it just kind of depends on your own personal circumstances, whether or not bankruptcy is that best option for you, or if there's an alternative route that you could possibly take. A lot of that is going to be looking at what's your total debt, how many of your creditors are coming after you. For me, with my clients, a lot of the time has it been more than 4 years since you've defaulted on the debt? If so, we really take that into consideration, because under Texas law for breach of contract, it's a 4-year statute of limitations typically. So anyway, something that we assess. Also look at your assets, exempt and non-exempt. and really what kind of liability do you open yourself up for. And so with that, I know that's a lot of information. I know I also talk quickly. So I wanted to open it up for questions if anybody has any, and if not, I will make up questions based on questions that I get all the time from potential clients and from clients.
Oh, I don't have any here in the chat, but let me look back at the email. So you can go ahead and if there's other questions that actually come to mind, but I did actually have one. What's generally the time frame when somebody starts the bankruptcy process till it's, done?
Yeah, that's a great question. So there's kind of two answers. The time frame from when we file the bankruptcy, that's pretty clear and cut. That's 90 days. So it's if we file today, 30-ish days from now, we'll have the meeting of the creditors. If all goes well there, 60 days later, you'll have the case discharged and ideally closed as well. And I'll mention why I said ideally closed. So that's a 90-day period. However, I will let you know a bankruptcy petition and schedules is typically somewhere between like high 60 to maybe 80 pages. It's a lot of information for like me as an attorney to have to draft. I have software that helps with it, but it is a lot of information. So the issue that we kind of come up against, I have only had one or two clients before who said, here is everything that you need all at once, and I'm ready to go. And they did that like kind of right at the beginning. Most people it's, oh, okay, well, here's my driver's license and social security card. Here's a couple of pay stubs, but they may be missing everything else. We kind of need everything in order to get the bankruptcy started and to get the bankruptcy petition drafted. I mean, I can draft it with just the intake form, but we don't have everything that we need. So a lot of it really depends on the individual and how quickly they can get us the requested documentation. After that, every firm will be different. And it depends also on kind of how easy your bankruptcy is. We would be able to draft, I mean, for expedited, we could do one in like 24 hours or so. But typically it's probably like a month or so to make sure that everything is good, finalized, reviewed. I'm reviewing 70 pages numerous times. And I ask a lot of the same questions that I already know the answers to.
Okay, there's another question here that had come. How much does bankruptcy cost? What are the legal fees?
That's a great question. So firms vary in range. I can tell you for a Chapter 7, I will be very honest, I don't know the fees for Chapter 13. My understanding is that they are much higher than a Chapter 7, but they can get included as part of the repayment plan with the creditors. So you could actually pay them monthly in that repayment plan. For Chapter 7, the filing fees. So if you were to do this on your own, get the forms, figure out how to do it all, you're going to be paying over $300 for the filing fee with the bankruptcy court. Plus, you'd need to pull your credit report. Plus, you need to pay for the credit counseling and financial management courses. You're probably looking at maybe another $100 to $200. For a bankruptcy firm to handle it, you're probably looking at fees. I would say average is maybe around $1,500. I've heard as high as $2,500 or $3,000. I'm not sure if that's just for more complicated. I'm not really sure why that's a fee, but I mean, but anybody can charge anything they want, I suppose. So, but I would say you could probably find somewhere between maybe a 12 to 15 or 1,700 range.
And what have you seen has been the long-term impact as far as like on your credit or whatever when someone actually files bankruptcy?
So here's the thing that worries me is, I know I mentioned this earlier as well. I have had a lot of clients say, hey, I'm getting credit card and loan applications. And it's like immediately after the bankruptcy. So a bankruptcy trustee will tell you that, and it is true, it may be or will likely be more difficult to get things on credit after a bankruptcy. In my experience, creditors know that you can't file again for another 8 years. So it may not actually be that difficult. But with the caveats there being, if you're trying to get a mortgage, if you know that you want to try to buy a home in the next couple of years, I suggest avoid bankruptcy at all costs, because that's going to be very difficult. If you want to get a loan for a vehicle, that will be more difficult. It's not impossible. I think, you may not get financing through the dealership directly, but you may be able to go to, let's say, a credit union, but it can be more difficult, and you probably wouldn't want or be able to do it for at least a year after filing. And then renting, again, some landlords, they do care. They typically ask on like a common application. But that's really entirely dependent upon the landlord as to whether or not they would want to have a tenant who's filed bankruptcy within the last, 8 to 10 years.
Have you ever seen where a creditor, where someone's filed bankruptcy, but a creditor tried to still come back at them again anyway, regardless?
Um, yes, in a way. Typically, this just happened to come up the other day, and I was like, this is interesting. And I said, I really need to look at the bankruptcy petition because I'm confused as to why these creditors, were they not named? And so that's the thing too, is sometimes people, I would say medical debt, like medical debt usually does not pull up on your credit report and people forget it all the time. So in my experience, most creditors tend to err on the side of caution. They're like, look, if this debt existed before the bankruptcy, we should have been listed. So like, we're gonna kind of, wipe this or, wash our hands of this. But there's some that maybe they say, well, I wasn't included. I don't think that's very likely though. I'm trying to think if there were any other creditors that would do anything. I mean, no, typically they're pretty worried. They don't want to do anything that would violate any federal bankruptcy laws. So they don't typically do that. What can happen though is a creditor can file something called a proof of claim in the bankruptcy. So if they believe they have a claim that should be paid, let's say there was like a pending lawsuit or like for fraud or something, they may be able, or not only that, if there's any non-exempt assets that get sold off, they could get paid for that. But I don't ever usually see it. It's like after the bankruptcy.
Which generally the time frame for when you accumulate debt that you can actually file for bankruptcy on. And I'm asking because it's like, can somebody go out and rack up a bunch of credit card charges, get a bunch of cars, and then immediately turn around and then file bankruptcy?
Thank you. That was it. I was
Yeah.
like, I know there's another situation, and that was a situation I was thinking of. No, they would probably come back and say that constitutes as fraud. Like you knew you were filing for bankruptcy and then you did
Okay.
this. So typically what we recommend is people, because the trustee doesn't like to see that you're paying some creditors and not others. I have a lot of clients before who've said, well, but I still use this one, like, clothing store credit card. Can I keep that one open? Or I use this gas card, is it okay to reaffirm that? Can I keep that open? And I'm still paying on that, but none of my other credit cards. I say, nope, if you're not paying the other ones, you shouldn't be paying that one either. They're going to close it anyway. Like they're going to be careful. They need to close the card. You can't just pick and choose which ones that you want to keep open. And then same thing, if you ended up using a card, let's say you purchased, some electronics like a few days before filing bankruptcy, they're going to see that. the creditor will inform the bankruptcy court and there are going to be some issues there. So I would say at a minimum, you're looking at 6 months and possibly up to a year before filing the bankruptcy.
Now, is there like a certain time period where like a debt has to be like past due for a while, or you just having trouble paying it before you can file bankruptcy? Like, do they have to see that you've been struggling with making payments for like 6 months or however long before you can actually file?
Not really for filing bankruptcy, because again, keeping in mind, let's say somebody had $250,000 in medical debt, but they've been keeping up on all of their credit card payments until that happened. That doesn't prohibit you. It's not like, okay, well now I just need to wait. You would probably stop making payments on those credit cards in preparation for filing the bankruptcy. But it is different if a creditor is going to sue you. But that's, I know, a very different discussion. Typically it will be 6 months. So what will happen is you default on an account within at least 6 months, within at least 6 months, they can do something called a charge off, which means that they're deeming the account as not being collectible. And at that point, they could go after you, they could file a lawsuit. So I think if you've heard anything like that, it's probably more in relation to when they can actually sue you. You couldn't really default this month on like a credit card or a personal loan and then file a lawsuit against you next month.
Gotcha. Okay, and then and things are kind of coming to mind here as we're talking about this. So I completely just went blank when I just said that. I should have just asked my question outright. The types of debts that are included in bankruptcy, is it only the debts that show up that are on the credit report, or just bills that you owe in general, like regardless if they're reported to the credit bureaus or not?
Yeah, the ones in general, similar to medical debt, which doesn't typically pull up on your credit report unless maybe it's gone to collections and
Mhm.
maybe they're reporting it. But it would be sort of incumbent upon the debtor to include it in the lawsuit. Again, I think it can still, if it was incurred before the bankruptcy, it should be included anyway, but it's better to remember, right, and to include it. And then, so like when I am drafting the bankruptcy petition and the schedules, we can import the credit report, but I also have a list and say, tell me other creditors that you may have. So like, I won't know individuals that you owe. If like all 10 of your neighbors lent you money before, we would need to name them in the bankruptcy, and we wouldn't have that information outside of you. So it's best to try to include it in the bankruptcy.
So what about like utilities and things like that? Because I know people have now been getting astronomical utility bills, especially, with it being so hot lately and what have you. So if they're behind and then that goes to a collection, then can that be included as well?
Yes, that can be. Yeah, we haven't, well, that's a good question. You're saying like a water or electric bill. Um, so there's sort of an interesting aspect of timing there. So I think that you should be able to include it in a bankruptcy, but if you're like still in your same house with the same electric company and you haven't paid, I mean, they can still shut off your electricity, right? So that's the only thing. But let's say it's like from something in the past. Or one thing that we see often, it's collections for like an old apartment complex or a place that you've rented from. You can list that. That's usually what we see more often, or like phone bills, those get included pretty often, or even like solar panel bills. So again, those can get included, but you're not going to get to probably keep subscribing with the same phone company.
Right, right, right. Okay. Trying to watch Facebook here. I don't see any questions that are listed there either. And that's all I've got in my chat here. I don't see anything else that's listed. So again, this is your opportunity. If you have any questions or any kind of concerns related to bankruptcy, please feel free to ask now.
One other
Yeah.
thing I was going to bring up, and unless and until we have questions, is because this came up recently with a colleague of mine, and they said, "Hey, my bank, or one of my clients, it was a personal injury client. They just filed for bankruptcy. What do I do?" And I was like, "Okay." So most of the time, because I used to do personal injury law, and even in my engagement agreement with my clients, there's a bankruptcy provision that says like before you file bankruptcy, you need to speak with me first. What I've seen, especially in like class action lawsuits, is what will happen is a few things can happen. The trustee may go to your attorney, your like personal injury attorney, and say, "Hey, can you put a value on what you think this case will be worth, and what money everybody's going to get?" So most personal injury attorneys don't want to do that because that's assigning a value that they don't necessarily want to do early on. Um, and it can also mean that they may not get their attorney's fees. It may mean that any recovery that should go to the plaintiff in that case would actually go to the bankruptcy court. So sometimes that happens, and it's firms are like, "But I've spent all this money, on these experts or this and that." So it's just always important to discuss that with your personal injury attorney first. And when people call me, that's always a question that I ask them: "Do you have any claims against third parties? Do you have an attorney? Do you have any pending lawsuits or potential claims where you're demanding money?" And if the answer is yes, well, we're going to need to talk. You need to talk to your personal injury attorney first, because that's your relationship. And then if you want me to have that discussion too, we can have that.
Okay, another question that just popped in here. Is there a charge for the assessment to determine eligibility to file for bankruptcy?
No, not that I'm aware of. I think so for us, our software, yes, it costs money. And so we input everything there, and it gives us like this nice, green thumb or a red thumb if there's, it's called a presumption of abuse. So if you're if you qualify under the means test, then it will get this green thumb and there's no presumption of abuse. But in order to do it on your own, I believe you could go either to the DOJ's website, or maybe the various bankruptcy courts may have their own means test calculator. I think there are free ones online that you could go to. It just takes kind of knowing what information to include, and then how to kind of read it at the end. I'm not sure if they do the calculation for you, or if it just gives you like the baseline and then you have to do your own calculation. But that being said, you can contact most attorneys if you were looking at Chapter 7. And I usually just say, let me see your pay stubs. If you were close and on the cusp, I may ask for more information, or I may want to look at your monthly income and expenses. And I have like my own form to be able to review that. And I think the thing that gets most people is they really struggle with this concept of having to provide information for everyone in the household who's earning a living, who has income. Typically, the bankruptcy court, they ascribe to the test of how many heads on how many beds. So if you have 4 people living in your house, and maybe not just temporarily, sometimes people are like, oh, I have somebody who stays with me like a couple weeks out of the year. That's different, right? But if on a daily basis, you typically have 4 people in your household, then we need to look at all of their income. If you're a roommate, that's a bit of a different story, right? Because they're not really a part of your household.
How would they know, or how could you determine who's part of your
Right.
household, or how would, oh, okay.
Right. Yeah. Yeah. If you're just like a roommate situation, yeah, that's just different, because they're not a part of your household.
I mean, even for, especially nowadays, you got people that are falling on such hard times, and with the high cost of housing, people are moving back home. Folks are moving home with their kids and sharing space with their parents and things like that. Do they still consider that income as well? If it's like their parents or something like that?
Yeah, they likely would. Now, I would say the benefit of that is, let's say you've got a child who's moving back home. That's just kind of an easy one to think of. Like they finished college and they can't get a job and they're moving home. Yes, you would include them, but there's a good chance if they're living at home, they may not have a ton of income. So, and if let's say your income is higher, it may actually equal out to make it a little bit easier on the means test. It just kind of depends. I think the idea though, this is just how I kind of qualify it to my clients most of the time is, let's say you have a spouse who's like independently wealthy, like they're just a millionaire. They're still going to look at their income, and you don't, at least in a state like Texas, you don't get to have a spouse who could be supporting you in that way, but isn't.
But there is no impact per se on the people that you're actually living with if someone were to file bankruptcy. So there's no financial obligation there whatsoever, even though they're considering their income.
Yes,
but
that's
there's
correct.
no, okay. All right.
Yeah. So let's say, yeah, even if you have a spouse, because some people will say, hey, I really want to make sure that my spouse, like what happens a lot of the time is it's sort of like a second or third marriage. And it's, hey, I got into this debt before my new spouse and I even knew each other. I don't want them to be responsible. I don't want this to affect them. And it really shouldn't affect them at all, other than the fact that we're just going to need to know their name and know their income information. It doesn't affect their assets or anything. Again, and when I say joint debt, I don't mean just you took out a credit card and you're married, so that's your spouse's joint debt. I mean, if you both are listed on a credit card, or let's say it's myself and my spouse, and we're both listed on a credit card and only I file bankruptcy, that credit card, they would still owe that credit card. The bankruptcy doesn't do anything for them and their responsibility on that credit card, if that makes sense.
Could the spouse be be solely then responsible for any debt that's incurred during a marriage if one spouse actually files for bankruptcy? Because I actually saw that happen with someone that was separating and filing for divorce. The spouse that left went and filed for bankruptcy, and then all the debt was left for the other spouse to actually now be responsible for.
Exactly. Yeah. And I see that happen pretty often too. Typically
Wow.
what happens with my clients is I think it's usually there's another thing that happens a lot, and this is usually what happens with my clients, is that the debt is only in their name because they decided in the marriage, hey, you've got better credit. Let's keep it nice and clean. We'll put the debt in my name, but we're both going to be paying for it. And then all of a sudden you get a divorce. And unless you have an agreement in like a divorce decree that says this is how we're splitting the debt, because it's in your name, the creditors will go after you, right? Like they may not be financially and legally responsible for it if they're not listed on it. Again, unless it's like in a divorce decree. So I ask that of people too, and they're like, well, really, it was my spouse that did all this. I say, oh, do you have anything in writing? Like you would still, that's usually with lawsuits though, but I'm like, you would still owe it to the creditor because the creditor doesn't care how they get paid, but you could go after them for it if the divorce decree, because that's a contract that says, or hopefully it says how the debt is supposed to be divided.
But that's prior to someone actually filing bankruptcy though, right? If you were to get
Correct.
divorced, yeah.
Right,
But if you
exactly. No,
file
you're exactly
bankruptcy
right.
before, if you file for bankruptcy before your divorce, then the spouse could still potentially be responsible for all of that debt.
Well, even after the divorce, it doesn't really depend. If after the divorce, because a lot of people don't think about debt, or they don't realize what all debt there was. So it really doesn't matter if you haven't made a determination. And well, again, let's go back to your original example, is if the debt is included in both my name and my spouse's name, and we get a divorce or we're going to get a divorce and I file for bankruptcy, again, they are personally and individually liable for that debt now, without, like, the creditor can't go after me once I file the bankruptcy. So that's kind of the tricky
Wow.
part about it, which does happen. Yeah.
Wow.
So
Wow.
that's why if that happens, I do have that conversation with people and I'm like, what this means, right? And I can't think of anybody that I've had where it was actually under both of their names. I have had clients who are like, I assumed all of the debt, so now I'm filing bankruptcy for that reason because they're not going to help with it. Or I just don't want to deal with them. Like it's just easier for me to file bankruptcy. I tend to see that happen more often.
Mm,
I don't think
wow.
I would personally feel good if I knew that it was jointly named and then this person would be discharged. I'm sure people do it all the time, and it's not that they shouldn't, but I think I would have an issue with that personally.
Wow. 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 Hey, but you never know. You got all these different scenarios that pop up all the time. So people just need to be aware, which is why we're
Mhm.
providing this information. Oh, goodness. All right. Well, I think that's all. It was a lot. I mean, that's a lot. That's a lot to take in, especially when you're thinking about, your personal finances and what could potentially happen. And I can imagine, with COVID, even with COVID. Okay, so another example, pandemic happens.
Mhm.
Have people just been filing for bankruptcy, or if they're still going through these financial hardships, bankruptcy is an option for them if they qualify because of COVID?
Absolutely. Absolutely. Now, one thing to consider though is if you, let's say you were earning, I don't know, like $100,000 before you got sick or something came up, and you think there's a chance that you could get a job in the future that could kind of, cover these expenses, but it may be like, hey, but it's going to take me a few years before I get back there. Um, time, less time is kind of your friend in that scenario because we're looking at what is the last 6 months of your pay or your income. And then they use that to calculate your annual income for the means test. So now I'm not saying you would not want to commit fraud in the court. If you know you're about to start getting paid like a huge sum of money, that's different, right? But if you're like, look, I think I could work in the future, but like I'm still not feeling well. I have what do they call long-term COVID, or whatever else. Um, you may want to do it sooner rather than later. But there was somebody I talked to recently. I'm going to be very honest. If you were young, Like people that I talk to are in their 20s or 30s who've never owned a home before. I say, do you think you ever want to own a home? And if they say yes, then I say, okay, and I talked to somebody about this not too long ago. I said, do you think there's any chance in the next 2 years you're going to have a decent increase in income? And if they say yes, I think I will. I just haven't been able to find a job now, or I'm just sort of recuperating from all of these things. I like, let's talk about other options. I'd really like to help you avoid it because getting a mortgage is going to be really tough. But sometimes it really is the light at the end of the tunnel. And I think not having creditors constantly call you is a huge relief for a lot of people.
So for those folks that have gotten behind on their mortgage, they're in the process of being foreclosed on and things like that, would you recommend bankruptcy as an option for them to help with stopping that foreclosure process?
So I'm sure there are more options than this, but once it's reached that stage, as far as I can think of, I'm trying to think of other potential solutions. You kind of have 4 options, I would think. You can lose the house. You could try and refinance, but yeah, I don't really know how you're going to be able to do that, right? Because your house is already in foreclosure. So I don't really think that's feasible. You could try and negotiate with the lender directly, which you probably at this point already have, and maybe, what they want is just like so obscene that you just can't afford it. Or yeah, I think you're looking at maybe a Chapter 13 bankruptcy, because that's where you go on a repayment plan.
Yeah, because I've seen, or I have heard, even going through some of my real estate clients and people through home buyer education or what have you, where they've lost their jobs, and they can't find the work in that same field that was paying them that amount of money, and now they've gotten so far behind they can't qualify because of what their previous income was for the Texas Homeowners Assistance Fund, things like that, or they're over that income limit to actually even qualify with the current employment that they've got. And it's not enough to cover the past due of what's owed or what they haven't been able to pay. And then, to try and refinance, you can't qualify to refinance because now you no longer have the income that you had before,
right,
to cover that particular kind of mortgage. So
exactly.
what do they do? Oh my God.
Then the other option, the thing I say too is, do you have family members or friends you can go to? Just see if you can get caught up. And so the thing with creditors too, and I should say not all creditors are created equally, but for the most part, what I hear from at least their attorneys, so that's different because that they're running a lawsuit, so things have changed at that point, is they really just want to be kept informed. Now, that has its limitations though. Some people will say, but wait, I was paying $20 a month to this creditor, or I thought we had an agreement that they would just continue to allow me paying this. And I'm like, no, on like a $25,000 debt, depending upon who the creditor is, no, they were taking it, but that doesn't mean they were agreeing to it necessarily. And so it can be a little confusing because you start to think, well, but wait, I thought that we had an agreement, or why aren't they working? That's what I hear all the time. I don't know why they're not working with me. And I think the trouble is, we're looking at like a David and Goliath scenario, of course. And so, as far as debt lawsuits go in the state of Texas, there are tens of thousands of debt lawsuits being filed in Texas every month. So it happens a lot. And unfortunately for, I think, those good seeds that are like, I was communicative and I was trying to make some payments, or I was at least letting them know, like, I will pay once I get a job again. You also have a lot of not so great seeds that are just defaulting without any communication, or without really, according to the creditor, probably any rhyme or reason. So I think the system, is kind of created that way, kind of because it's a numbers game. There's so many creditors and so many debtors, but also the few bad apples kind of spoil it for everybody.
Okay. And I don't want us to get too far ahead of ourselves. We're going to get into debt collection
Right.
next month on the 7th. So if anybody's that are joining us right now, we have a debt collection presentation that's coming up that Megan's going to be presenting on Tuesday, November the 7th. So come back and join us for that session as well. So again, I don't have any more questions that are on Facebook or that are in the chat here. So I believe that's all we have. So again, this was a lot. So I appreciate you. And I know that I'm definitely going to have to go back and listen to that part at the beginning again, just to make sure that I have a better understanding of everything and how it actually works. Well, someone she's joining a little bit late, but that's okay. But yes, so for all those that registered that were not able to participate or to hear the presentation, again, I will be emailing a link to everyone to go back and view the presentation. If you know somebody that's experiencing this financial hardship and they're contemplating if bankruptcy is an option for them or something that they may have questions about, please pay it forward and share this information with these folks that may not necessarily have known about this particular workshop. Because it's a lot of great information. It's a lot of great information. So again, thank you very much, Megan. We will see you next month for our debt collection, and actually next week too. Are you
next
here?
week? Yeah.
Yeah, next
Yep,
week.
next week.
You're doing small claims. It's small claims court next week. Okay, so you want to give a brief commercial real quick about what you're going to be discussing for next week for, as a promo?
Well, and I was getting confused if next week was small claims or debt collection. So thank you for reminding me. Yeah, with small claims, I'm planning on talking about the common types of cases that you see in small claims court. There's some big changes in the last few years as far as the jurisdictional limits. So now it's a $20,000 limit. So you see a lot more cases in Justice of the Peace Court as if we didn't have a lot already. A little bit about the rules in Justice of the Peace Court, because they are very different than in some of the higher courts in county and district. And then also just some resources that a lot of the courts provide online. It is considered the People's Court. A lot of my cases are in Justice of the Peace Court. It's always helpful to have an attorney, but there's a lot that you can do on your own and empower yourself to do. So talk about that.
Well, speaking of small claims, can people file bankruptcy to avoid paying out in small claims?
Most debt lawsuits are, not all, but most are in Texas too. Every state is different, right? But are small claims cases. Because in Justice of the Peace Court, I mean, it's pretty much, there are other things. It's like debt lawsuits, evictions, and then just other stuff, right? Like, you're suing your neighbor because of an issue with your dog or something.
Let me ask you this real quick. And it kind of triggered me when I was talking about COVID and people losing their jobs and businesses that are closing. Some businesses that have closed that still owed money to their employees, but then they go and file bankruptcy and then turn around and go open up business somewhere else. What do people do in that regards when you've got an employer that has done something like that?
So again, it also kind of comes down to assets, right? So if the business has any remaining assets, then what those employees would want to do is they would need to file a proof of claim in the bankruptcy, so that if there are any remaining proceeds, then the trustee will use those funds, and that's from the selling of non-exempt assets. The trustee will use those funds to distribute in some way that the trustee determines to the creditors. And so those employees could be considered as like creditors essentially, and they can file a proof of claim. And I've seen it done before. I saw one a few months ago, because I should have mentioned too, the 341 meeting, it's public. So it is telephonic, but there will be other people on the call. You get to hear other people, they get to hear you. When it was in person, it would be rooms filled with people and creditors. And we listened to one, I mean, and it was a lot of upset and sad people, not employers, or employees. I think they were like homeowners, and it may have been a builder that had gone under. I mean, and it lasted a long time. So, but you can file a proof of claim in case there are any proceeds left over. You could potentially get some compensation.
Are there any restrictions for businesses when they are filing for bankruptcy and then they go and they start another business?
That's a good question. I think it kind of depends too on what kind of bankruptcy they're filing. And I just don't know enough about Chapter 11 to know what that is. Usually I think they get to keep the business open, right? And it's just sort of like
Mm,
a restructuring and things. If it files Chapter 7, I mean, that's always interesting because usually if a business is filing Chapter 7, the individual who owns it is probably also filing Chapter 7. I mean, I won't say always, but a lot of the time because they were also, it used to work, it's been a long time, that you could get, let's say, a line of credit or a loan for your business and not have to personally guarantee it. Those days are pretty much gone. I mean,
mhm.
all business owners pretty much have to personally guarantee something. The credit cards in there, it's really difficult even to get a credit card for a business until it's been
Yeah.
around for a while. So most of the time you would see both filing. Even with the business, I always question, like, why are they filing Chapter 7 versus just, I mean, they're going to shut down the business anyway, but it's because they have assets. So the business is filing Chapter 7, the business probably has some assets that need to be sold off, and that compensation given to the creditors. Um, so I would probably need specific examples because I'm not certain if they're getting like loans through other people, individuals, or how they have the money to go and start these other businesses. But if it's really just like a ground up thing, I mean, unfortunately you can. And that's why I think credit counseling and the financial management courses exist, to try to educate people so that they don't end up in those similar
Good
situations.
position. Mhm.
Yeah.
Good, good, good. All right. Again, thank you very much, Megan. Really appreciate you taking the time this afternoon, and I'm definitely looking forward to your next couple of presentations as a follow-up to all of this, since they all kind of go in line in one form or another. So we really appreciate you. Thank you all to all of our participants who are joining us this afternoon and continuing to come back and support a month of service collaboration. We are in the process of planning for our 2024 schedule. So if there are any topics that we did not cover this year that you guys are interested in, then please feel free to reach out to me and let me know. Again, I'll be sending out an email to everyone that registered here today, so you'll have all of my contact information. If you're joining us on Facebook and you're watching on the Amos page, then feel free to type a comment or something in the chat if there's some information that we're not currently covering that you guys may be interested in as well. So again, thank y'all very much. Enjoy the rain. Definitely enjoy the rain that we've got out there today, and hopefully it kind of cools it off a little bit and it doesn't making it back hot again or something. So you all have a wonderful remainder of your afternoon, and take care of yourselves, and you all stay safe, and we will see you next time.
Thank you so much.
All right, thank you.